my goal is to provide news, people can use, and especially judge people and lawyer people. You know, it's a great question whether Bruen is a good idea or a bad idea or whatever, but my goal here is to try to figure out how it can be turned into usable law. I tried to do the same after Heller, wrote an article called Implementing the Right to Keep and Bear Arms, and seemed to be pretty practically useful. So I thought I would update it in light of the very substantial changes that Bruen has created. So let me quickly run through the general framework, and then I'll talk very briefly about some of the key issues. The current draft that I've shared with the other panelists is mostly about the general framework, but I plan to follow the general framework with kind of some guesses at the proper application of all this. There are, if you think about pretty much all constitutional rights, there are 4 categories of reasons why a restriction on a constitutional right can be upheld. One is that something might be outside the scope of the right. A second is that a restriction may not be a sufficient burden on the right. It may touch on things that are within the scope of the right, but just not really burden the right that much. Another is there might be a sufficient government interest supporting the restriction. That's where strict scrutiny, intermediate scrutiny, and the like come in. And another is the government may be acting as proprietor of its own property. Could be real estate, could be a paycheck it pays to an employer, to an employee, and the like. So let's think a little bit about how this plays out in other contexts. So let's look, for example, at content-based speech restrictions. There are specific kind of scope-based exceptions: libel, incitement, fighting words, obscenity, let's say, a few others. However, you generally can't, once the speech is within the scope, you can't justify a content-based restriction generally simply because it imposes only a very mild burden. In part because since it's an equality rule, the court's view is even a penny tax on some constitutionally protected speech, that's presumptively unconstitutional. But only presumptively. The court has told us there's a strict scrutiny test afterwards that in some situations might validate such a restriction. And there are these government as proprietor rules as well, government as landlord, employer, and such. Now let's look at another kind of restriction, a viewpoint-based speech restriction. There are a few scope exceptions to that rule, the rule that you can't have viewpoint-based speech restrictions. Incitement might be an example. It's a very narrow exception, but still it targets speech with a particular viewpoint. You should commit a crime. Again, any kind of burden, viewpoint-based burden on speech, I'm setting aside things like what, for example, the court says there's just not a burden because it's just government controlling its own speech. But any burden on private speech is presumptively unconstitutional. And maybe it's an irrebuttable presumption. There are at least a couple of cases where the court has mentioned, albeit kind of in passing, there's a per se rule of prohibition, that it's just categorically unconstitutional to have a viewpoint-based restriction. But again, there might be some exceptions when the government is acting as proprietor, like employer, maybe, and the like. Let me just again try to confirm. Are you guys seeing this array, this kind of table with 5 columns and what, 8 rows besides the headings? Is that visible?
Yeah.
Hello?
Yes.
Okay, good. So then let's look at content neutral speech restrictions. Time, place, and manner restrictions like on the volume of demonstrations or on blocking traffic. The scope is speech or inherently symbolic expression is presumptively protected even against content neutral restrictions. But here, the burden is actually makes a difference. So for any burden, in principle, the restriction is subject to a relatively weak form of intermediate scrutiny. But if it's a grave burden, like there's no ample alternative channels, then subject to strict scrutiny. By the way, in most circuit courts before Bruen, this was more or less the test that the court announced for the Second Amendment as well. That there were scope exceptions, which are different, of course, for the Second Amendment than for speech. But if there was a burden, then it would be intermediate scrutiny, pretty mild form of intermediate scrutiny. But it was a very grave burden, then at least some courts said, well, strict scrutiny is the test. Likewise, we see something similar for free exercise under Sherbert. You need to have a sincere religious belief that gets you within the scope of claiming a religious exemption. Again, that's under the old Sherbert-Yoder test, which the court may be reviving now. There's a substantial burden threshold, and then there's strict scrutiny, which might justify the restriction. One reason, by the way, for slicing and dicing this is it's a reminder that sometimes people oversimplify and say the test for free speech restrictions is strict scrutiny. Well, it's not, right? You could have some restrictions that are upheld under strict scrutiny or struck down under strict scrutiny with our content-based restrictions. Others, the scope kind of restrictions like on libel and such, strict scrutiny doesn't even apply. And for content-neutral restriction, what scrutiny applies turns on the burden. Now, interestingly, the other thing when people say, well, the test for all individual rights restrictions is strict scrutiny, is that's just not so for certain rights, usually relatively narrow criminal procedure rights. So let's look at the criminal jury trial right. Generally speaking, its scope is for all criminal trials except for petty offenses. I oversimplified here, but there is this historical scope exception based on the judgment, right or wrong, that throughout American history, starting with the framing, petty offenses weren't subject to jury trials. Presumably, any burden on the right is unconstitutional, or maybe not. I found at least one case, for example, where there were jury fees imposed, and the lower court said, well, you can't do that because you can't burden this right to criminal trial by jury. And then it's a per se rule. I mean, let's say the government were to say, you know, we're really worried about hate crimes enforcement. We think in some places the juries just won't convict people of hate crimes or of lynching or of whatever else. So we're just going to waive jury trial rights on the grounds that there's a compelling government interest in enforcing hate crimes law or enforcing lynching law, and the jury and prohibiting jury trials in those cases is narrowly tailored. No, the court presumably would say. It would say categorically, you have a right to jury trial. Now, by the way, sometimes in some of these criminal procedure cases, there is a strict scrutiny override, for example, for the public trial right or the compulsory process right, but not for jury trials. By the way, something similar with civil jury trials. In fact, my understanding is the reason the Civil Rights Act of 1964 did not include common law remedies like damages and punitive damages is precisely because if it did, there would need to be jury trials. Just categorically, there would need to be. Although for the civil jury trial, right, modest burdens are probably constitutional. For example, modest fees. Abortion rights under Casey, back when there were abortion rights under Casey, similar thing. You had to have substantial burden showing in order to get to have a valid claim. But once there was, at least in principle, it looked like there was no further compelling government interest in it. And the Second Amendment, Bruen says something similar, that there's a scope rule defined by history and tradition. Then there's a per se rule of invalidation. But, and here's what I want to talk about for the rest of my time, it's an interesting question. Is there like a substantial burden threshold for invalidating gun controls under Bruen? And also, what would be the rules for government as landlord, employer, and such? So for scope, I'm not going to talk much about it because everybody's heard that there are these historical things, whether or not really well-founded and whether it's easy enough for courts to actually figure out what the scope restrictions are and to analyze the history. Separate question. But the court has said there are these scope-based exclusions. They won't necessarily pass strict scrutiny, like, for example, a categorical exclusion of felons. Maybe it's not narrowly tailored to compelling government interest. Likewise, bans on concealed carry, which the court has said are constitutional if they allow open carry. The court didn't justify them under strict scrutiny, it justified them under just the history that concealed carry was often very heavily regulated or banned in the 1800s, excuse me. But so here's what I have in mind as to burden. Let's look at the footnote where the court said that shall issue regimes are constitutionally permissible. So why are they permissible? Because they don't necessarily prevent the exercise of the right. They have a good purpose. They're aimed at enforcing some of these scope restrictions. They aren't likely to be misused, the court says, and they impose only a modest burden, at least when properly enforced. Not lengthy wait times, only modest wait times. not exorbitant fees, only modest fees. And anything beyond that would deny ordinary citizens the right to public carry, and that would be unconstitutional. So really what this is saying is that a really serious burden on the right to carry guns, like a total prohibition or almost everybody prohibited the way that was in practice in New York, or lengthy wait times or exorbitant fees, that's unconstitutional. But a modest burden, modest fees, modest wait times, that would be constitutional, at least if it's in the service of a legitimate interest or sufficient government interest. There are other times when the court says the same. None of these restrictions imposed a substantial burden, historical restrictions in public carry, analogous to New York's burden. That suggests that the magnitude of the burden is important. Likewise, about the burden of the surety statutes that the New York tried to analogize to the court, so that's a relatively modest burden. And again, it talked about comparable burden and whether the burden is comparably justified. How and why the regulations burden a law-abiding citizen's right to armed self-defense. So that suggests that at least certain kinds of restrictions, whether I like them or not, I mean, not all of them would necessarily be good ones, I think, but might be constitutional on the grounds that they only impose a modest. So what possibilities? Well, what about fees? So New York, I think, has or at least had a $340 licensing fee for even possessing guns in the home. And the Second Circuit upheld that. Interesting question whether it would still be seen as a modest fee or an exorbitant fee. Commonwealth of the Northern Mariana Islands tried a $1,000 fee. District Court there struck that down. So that's one way in which it might play out. Training requirements, which the court mentioned, suggest that they're permissible if they're not too burdensome. They're not like a week of training or something like that. Waiting periods might be not burdensome, at least not unconstitutionally burdensome if they're short enough. Insurance requirements, something similar. I think a lot depends on how expensive the insurance would be. Likewise, when the court said restrictions on gun sellers may be constitutional, I think the real question is how much do the restrictions burden gun buyers and gun owners? It's not a right to sell guns, but the right to keep and bear guns presumably includes the right to buy them, just like the right to have contraceptives includes the right to buy them. So restrictions on gun sellers, I think, would be evaluated through a burden perspective. Likewise, serial number requirements. There was a case from, I forget which circuit, maybe the Ninth Circuit, which shortly after Heller said, well, you know, there's this law that bans guns without serial numbers. Well, how much does that interfere with people's ability to defend themselves? They're still free to defend themselves. You just need to defend yourself with a gun with a serial number. Interesting question. What about bans on so-called assault weapons? I'm not a fan of them because I think, generally speaking, most assault weapons, again, so-called assault weapons, are really not materially more lethal than lots of other guns that are not covered. But precisely because of that, that doesn't really substantially interfere with people's ability to get the guns that they need for self-defense. Just not this brand or not this look, but some other look. Now, Justice Kavanaugh, when he was Judge Kavanaugh, no, actually, maybe even now that I think about it, dissent from cert denial at one point argued that, well, you know, restrictions on that allow you to use some guns but not other guns would be like restrictions that let you read some magazines but not other magazines. But that's, I think, in part because, with magazines, not the gun magazines, but the readable magazines, we think they're not fungible, right? Reading the New Republican, reading National Review, and reading Sports Illustrated are very different experiences. But my sense is that, you know, for guns, that may not be that materially different with reference to the right to self-defense that the right to bear arms is supposed to be. Interesting question, likewise, about large capacity magazine bans, which might be possibly relevant to preventing certain kinds of crimes. And then an interesting question is, again, how much do they burden people? Let me just close with government as proprietor, because people don't talk about it. Sensitive places involves a lot of government as proprietor situations, but maybe it goes beyond sensitive places. Maybe just like the government can restrict speech in non-public fora, it could say or restrict abortions, even back in the era of Roe and Casey, could restrict abortions at government-owned hospitals. Maybe it could say the same with regard to guns. At the same time, you know, public streets, where Bruen tells us that's not government property for that purpose, just like I think for First Amendment public fora. What about public parks? Again, they're fora for First Amendment purposes. Are they likewise for gun rights purposes? What about public housing, where I think a lot of it is not terribly safe, and a lot of the people who live there particularly want to be able to defend themselves? What about the particular kind of public housing that is public university dorms? What about public employees carrying on the job, even outside the workplace? So these are the kinds of questions that I think would be hopefully filtered not through the Bruen scope, history, tradition discussion that Bruen talked about, but through government's proprietor rules like the ones that the court has developed with regard to the freedom of speech and the like, at least some of them, maybe not the public streets. So with that, I close. Those are my general ideas. I'd love to hear what other people think. And again, my goal is just to try to figure out how it is the courts can turn the framework in the Bruen opinion into something that is applicable, usable law.
Thank you very much. Eric, will you take up?
Sure. Kissing the mic. All right, I'm getting in close. Well, thank you. Thanks to Duke Firearm Law Center and to the NYU Law Review for inviting me to participate in this symposium. I'm thrilled to be back here at NYU, my alma mater, and where the late, great Jim Jacobs, who was a mentor and co-teacher with me, got me interested in thinking about gun policy and the Second Amendment many years ago. So my presentation is based on research for a work in progress that's tentatively titled Felons, Firearms, and Restoration. My research spans constitutional and policy issues, and with respect to the policy issues, I'm using criminological data about how people tend to age out of crime after a certain number of years to argue that lifelong felon disarmament without opportunities for restoration is very likely unnecessary in many cases and bad policy in an age of mass incarceration. And I think that these laws are ripe for reevaluation, and I offer some suggestions about how they might be reformed based on how states view the issue of restoration across the country. But this being a Second Amendment symposium, I'm going to focus the balance of my remarks on the very real possibility that permanent felon in possession laws could be called into question or struck down after Bruen, at least with respect to some crimes. And though I think that would signal an expansion of the right, I'm going to suggest that it's not all bad news for gun violence prevention advocates, in part because, again, I think there's a lot of space for reform in this context, but also because this is a category of law that I think might be very well suited for showing, Eugene, we can still hear you, just to let you know.
Oh, sorry. Thank you.
I also think that this is a category of Second Amendment challenge that might be well suited for showing how the Second Amendment might be implemented in a way that would preserve other reasonable gun laws. So to see why, I'm going to do three things. First, I want to briefly set the stage by describing the role of the felon in possession laws within the criminal regulation of firearms, and also the Second Amendment challenges to them in the run-up to Bruen. Second, I'm going to argue that Bruen leaves felon in possession laws exposed to constitutional invalidation, at least in some contexts. That said, I don't think that this Supreme Court is likely to strike them down in toto, which means that I believe that they will have to apply Bruen in a way that might be looser than some post-Bruen courts have been applying Bruen after the case came down in June. And that brings me to the third thing I'm going to talk about, which is going to focus on an aspect of Bruen that's a little bit different than what Eugene's remarks were focusing on, and that I'm going to look at that historical analogizing, which has been taken away as the primary holding from Bruen and has been very influential in some recent cases. So I want to begin with a brief summary of the role of felon possession laws as relates to criminal law generally and the Second Amendment challenges in the run-up to Bruen, in part because this is an area of Second Amendment law that's gotten a lot less attention than, say, public carry restrictions. But felon in possession laws are a main driver of gun prosecutions, and we heard a bit about this in the last panel, and a huge driver of incarceration for gun-related crime. In terms of Bruen's implications for criminal justice, this might be the most important category of Second Amendment challenge. Every jurisdiction in the country bans at least some category of felons from possessing firearms for at least some period of time. The federal felon in possession law operates as effectively a complete ban on anyone who's been convicted of a felony and certain misdemeanors. At the federal level, there's no opportunity for federal restoration of firearm rights presently. And if you've been convicted of a state felony, then the federal ban on possessing firearms following a felony will also kick in, subject to state programs for restoration of rights. But the most common state regime is like the federal one, which has no opportunity for the restoration of firearm rights. On the ground, again, felon in possession laws are driving a lot of incarceration and a lot of prosecutions. Gun prosecutions make up about 12% of overall federal prosecutions, and 60% of federal gun prosecutions are for being a felon in possession. It's hard to quantify the percentage at the state level, but the percentages are likely similar in the states where people have been able to pull the data. So in light of all those prosecutions, it might come as no surprise that this is the most common category of law that gets challenged on the basis of the Second Amendment. Joseph Blocher and I did an article that we published back in 2018, and we showed that 25% of all Second Amendment challenges were to felon in possession laws, and no other category of challenge was even close. And yet, before Bruen, this also was a category of Second Amendment challenge that was unique in how bad it fared. The failure rate was phenomenal. About 1% or just 1% of challenges to felon in possession laws had any success. And there are many reasons for this high failure rate. Among other things, Heller declared that it did not cast doubt on felon in possession laws. And because courts were applying heightened scrutiny, felon in possession laws generally passed heightened scrutiny. But as I'm not going to turn to now, I think those justifications carry less weight after Bruen. So the second thing I want to touch on is how in the post-Bruen world these laws are far more susceptible to successful challenge. And the reason why goes to the historical analogizing that Bruen says is required in order to shore up gun laws. Felon in possession laws do not appear to have existed at the founding. Rather, they really caught on in the first third of the 1900s, around the same time that the Sullivan Law was enacted. And as we saw in Bruen, that was too recent to create a historical lineage for the Sullivan Law that would uphold the constitutionality of May-issue permitting. And I think that lack of pedigree presents a challenge for post-Bruen constitutionality of at least some felon in possession laws, but also an opportunity in terms of how these are going to get litigated. Scholars already had reason to explore the lineage after Heller of these laws because the court said that its decision did not cast doubt on prohibitions on the possession of firearms by felons. The court declared those to be long-standing regulations. And in the wake of Heller, a number of authors and scholars asked whether or not these really were long-standing regulations, and they came up short in terms of framing era restrictions on the possession of firearms after a conviction. This task was made easier because Saul Cornell had already done a lot of the work digging up so much of the history around the framing era with respect to firearms. But whether or not that history existed, lower courts after Heller regularly rejected challenges to felon in possession laws through a cursory reference to Heller's statement that it did not cast doubt on these laws. So enter Bruen. The majority in Bruen did not repeat that it did not cast doubt on felon in possession laws. It did not repeat the Heller list of exceptions. It referred to some of those exceptions, like sensitive place restrictions, but it did not refer to felon in possession laws. To be sure, concurrences by Justice Alito and Kavanaugh, the latter joined by Chief Justice Roberts, did reference the felon exception, but neither of them actually tried to shore up that exception with any reference to history. I view the concurrences as being insufficient to uphold the constitutionality of felon in possession laws without at least some sort of historical analogizing. It's kind of like fixing a leaky faucet in a burning building. The faucet's going down, it's going to have to be rebuilt, and it's going to be rebuilt in the Bruen world. Now, I have a hard time seeing, as a realist, the Supreme Court agreeing that it's unconstitutional to, say, ban gun possession by somebody who's been convicted of a violent felony. And as I just mentioned, Alito, Roberts, and Kavanaugh are all on record saying that felon in possession laws are not in doubt. When she was a district judge, now Justice Barrett wrote an opinion, Cantor v. Barr, where she likewise said it's constitutional to ban gun possession permanently for violent felonies. But even if my intuition is true that the Supreme Court's unlikely to strike these down, the question is how they're going to do it and how they're going to apply historical analogizing to uphold those laws. And that brings me to the third thing I want to suggest, which is that this is a battle that I think GVP advocates might want to welcome. Because to uphold, in GVP, I'm representing gun violence prevention advocates, because to uphold these laws in whole or in part, the justices would need to apply Bruen at a level of generality, which might insulate other gun laws from successful challenge. So what historical precedent exists to support felon in possession laws? Then Judge Barrett's Seventh Circuit opinion, I think, provides one way that the court might proceed here. Barrett wrote that not only is it common sense to restrict the possession of firearms by people convicted of violent felonies, but history supports it. In particular, she pointed to laws barring possession of firearms by those who did not sign loyalty oaths at the framing, by Native Americans, and by slaves. Joseph and his co-author, Katie Carberry, have an excellent essay out which explores the history with respect to loyalty oaths and Native American restrictions. And Barrett argued that that history reflects how categories of people deemed dangerous by the legislature could be constitutionally disarmed. Other conservative commentators have likewise looked to those restrictions as a rationale for upholding felon in possession laws today. And significantly, historical prohibitions that are getting drawn on here do not involve barring gun possession because of convictions. Rather, they simply are legislative determinations that other groups should not have firearms. Of course, I'd be remiss not to mention that these laws present all sorts of problems beyond the Second Amendment, such as equal protection problems, but those problems did not prevent Judge Barrett from looking to these laws to come up with some sort of principle, a higher level principle that might be applied to uphold some felon in possession laws today. And that move from groups viewed as dangerous at the framing to dangerousness being the operative principle for an analogical process, I think is instructive in a couple ways. First, it underscores how dissimilar a historical law can be to a modern one while still serving as a sufficient analog. And second, it demonstrates how historical laws should be used to identify principles to guide analogical reasoning in modern cases. Both lessons, in turn, shine a light on some of the errors that we've seen in recent post-Bruen Second Amendment cases. And for the sake of time, I'm just going to reference one of them. So consider, for example, Firearms Policy Coalition v. McGraw, which is a case recently decided by a district judge in Texas. In McGraw, the district judge struck down a law prohibiting the possession of firearms by those who were in between the ages 18 and 21. And the opinion based that conclusion, that it's unconstitutional to prevent carrying handguns to those between ages 18 and 20, largely on the government's failure to come up with any framing era laws specifically focused on age. But if a court need not look solely to the history of felony disqualifiers for the purposes of felon in possession laws, the court should not need to look solely at the history of age restrictions for the modern constitutionality of age restrictions. Rather, dangerousness, I think, could just as equally serve as a principle that would guide decision-making with respect to age restrictions. And an outsized percentage of gun crime is committed by or against people between the ages of 18 and 20, a group that we now appreciate with the benefit of modern brain science, might have less impulse control, and be more dangerous with firearms. So, to conclude, in keeping with the theme of this panel, I think Bruen could have some real consequences for criminal law, and that is how, and not only that, but how the Supreme Court decides Second Amendment cases on other issues as well. Thanks.
Thank you very much. We're running a little late, and I'm going to seize the moderator's prerogative to do something that I apologize to the panelists for, which is to do something very annoying to them, which will be to raise some questions about their presentations and then not give them a chance to respond so that we can get closer back to the schedule. So first observation in particular about Cynthia's presentation and her proposal number 2, I think we need to think about, so in the paper as a whole, she makes some proposals for, I'd call it a general reform of the law of self-defense. Proposal number 2 is a gun-specific version of such a proposal. And I think that gun-specific versions might have raised independent constitutional questions in the way that we've seen, say, in the law of religious exceptions to, or failure to make. Well, anyway, there are areas where the gun-specific stuff might raise some questions. Second, on Eugene's general chart, and the bottom line, of course, about the Second Amendment, my sense of things is that we are, with respect to the Second Amendment, sort of where the First Amendment was in 1930. And so we do have a pretty clear sense from Bruen on the scope issue about the history and tradition. But I think that it'd be why, and then there are hints about some of the other columns, but I think it would be wiser to put question marks in all of those other boxes, because what he's got above there are sort of what the mature law in these areas was, and it is. And it turns out that there are lots of variants of what can go in each of the boxes. I just make one specific point about the per se rule, which, where one of his claims is about the criminal jury trial and imagine what would happen if. So there were an exception enacted for some specific kind of form. I just would note that in England, they did make a specific exception for terrorist trials in Northern Ireland, and the English courts were fine with these departures from the traditional jury trial. You know, we haven't tried it in the United States because the stress of those problems hasn't arisen here, but you know, I myself, being a realist, would say, well, who knows what would happen if the stresses were such as to create jury trial exceptions. So I just be more cautious about the bottom row than Eugene is. Then finally, on the scope issues, which is relevant to both Eugene and Eric's point, what Bruen says is that on the scope issue, the issues can be determined by history and tradition. First observation is the court has this, Justice Thomas has this footnote about what I call adversarial history. I think there are structural issues about adversarial history. For example, state attorneys general are likely systematically disadvantaged with respect to adversarial history because, as compared to both gun regulatory groups and call them Second Amendment rights groups, those latter groups can commission studies and plan strategic litigation and have the adversarial litigation history briefs sort of in the can, ready to be pulled out. State attorneys general have lots of other things to do, and they're unlikely to have that kind of resource available. Now, because there are NGOs on both sides of the gun regulation issue, the structural disadvantage of state AGs is not quite as severe as it might be, but I think there still are those kinds of disadvantages. My son-in-law, as a historian, was asked to file an affidavit where a district judge said, I'd like the historical briefs to be filed within 30 days. And his affidavit was, you can't do history in 30 days, basically, which seems right to me. And then just finally, and this is relevant to the felon in possession laws, we know that the tradition, the history and tradition test involves analogies, and we'll hear more about that in the next session. In the felon in possession, there's this unindicted felon in possession, somebody indicted for a felony is banned from possession, and the district court held that to be unconstitutional. One question about the analogy is going to be, what's the basis for analogizing? So there are two versions. One, I think the one that most people think about and is most prominent in the court's opinions, I think, is that dangerous felons are in some sense categorically dangerous. And there are a bunch of lower court cases pre-Bruen saying, challenging felon in possession laws by non-dangerous felons who committed non-dangerous felonies. But the other version, which is expressed in Bruen, is that these categories try to capture something about good citizenship. And people who commit non-dangerous felons, to take a random example, bank fraud, might not be good citizens. There's a terrific Steve Earle song about bank frauds and how they damage society. We don't know, we can't, at this stage, with basically one history and tradition case under our belt, we can't know how that analogical process is going to develop, and what the scope of the felon in possession laws, misdemeanor, non-violent misdemeanor possessions, well, they're domestic misdemeanor stuff. I don't think we can predict how that's going to play out, particularly in the context of, again, adversarial history. Okay, so we're now actually over time by more than it should be, and I'm just going to say thank you very much. These were really interesting presentations. I think the publication of them will be very helpful in advancing understanding of the law post-Bruen. Thanks very much.